On July 1st of 1971, the state of North Carolina, or perhaps Ohio, or maybe Alabama, depending on who you ask, joined 37 other states by voting to ratify the 26th Amendment to the United States Constitution, which reads in full, "The right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state on account of age. The Congress shall have power to enforce this article by appropriate legislation." The amendment was approved by a Senate vote of 94-0 and a House vote of 401-191 and was ultimately ratified by a total of 43 states, most recently South Dakota in 2014, while the remaining 7 states took no action. The Constitution did not initially establish an age requirement for voting, leaving that decision to the states, most of which set their minimum age at 21, which was in turn the age that Congress initially established in the Selective Training and Service Act of 1940 as the age at which men were eligible to be involuntarily drafted into military service. That act was amended in November of 1942 to lower the age of eligibility to 18 during the Second World War, provoking a movement to similarly lower the voting age, with proponents adopting the slogan, "Old enough to fight, old enough to vote." First Lady Eleanor Roosevelt supported the effort, and Dwight Eisenhower publicly promoted the measure in his 1954 State of the Union address. In 1970, Congress amended the Voting Rights Act of 1965 to lower the voting age to 18 in all elections, and the Supreme Court ruled that year in Oregon v. Mitchell that while the federal government could not dictate the voting ages in state and local elections, Congress did have the authority to set the age for federal elections.